Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna PC. Today is January the 14th of 2016, our first community conference call this year. We do it once every other Thursday. Today, I'm a little pressed for time. We have enough posted questions. I will not be able to take new questions. I had tweeted about it. I had put it on our firm's Facebook page. I had also put it on my Google Plus. So no new questions today, just the posted questions and their follow-ups. Okay, you all know the terms. Basically, this is an information call. When you log into our conference call, it tells you what the terms are. You all agree to that. That said, let me get started. First, I want to deal with the frequently asked questions, what I feel are questions asked quite a lot. Peter Pelk says something about a percentage arrangement, and I wanted to cover when you have a percentage arrangement in salary, how far can you go? I have always had a problem with percentage arrangements from several different angles. Here, um, the good doctor, the physician who has posted this question, Peter, has a envisaged or at least contemplated arrangement that they would pay salary based upon the amount collected. So, um, well, I think that's a problem for your H1 doc. First of all, generally speaking, for H1 and for green card, your salary cannot include terms that are variable. So, for instance, if you get a yearly bonus, but the bonus changes from year to year, you cannot include that as a part of your salary. Salary cannot include per diem. A lot of companies and a lot of employees get stuck with a lot of problems because per diem is being set up as part of the salary. Per diem is not salary. Okay. Benefits are not salary. So all three of these items are big problems when you talk about H1 and green card salaries. You cannot include benefits, you cannot include per diem, and you cannot include variable amounts such as bonuses. Okay. If the bonus is guaranteed in terms of the amount, then you can include it. Otherwise, this is not salary. How about a percentage? I can talk a lot about how percentages actually offend um, the Department of Labor regulations in H1. In PERM, for sure, you cannot have this arrangement that you're thinking of because this is not a fixed amount. Now, of course, green card is a job in the future. What if we have a different setup now and another setup when I actually get the green card? I think that's okay. But the problem is if you are on H1, this actually probably offends, in fact, almost certainly offends H1 as well. Okay, so I don't think this is a good idea, Doc. Your second question is once I receive the green card, should the employer have to retain an immigration lawyer? Why? Once you get your green card, why should they need a lawyer? Does the salary for the position have to be listed in the ads? Not in the ads, but the salary does get listed in the job order. Does it? Hang on, I don't remember. I don't think job order lists the salary, it lists the range. This is something you post with the Department of Labor. And then you have to have, the employer has to post an internal posting notice. That internal posting notice must contain the salary or a range where the lower end of the range is not below the prevailing wage. And it has other legal issues. Make sure your lawyers look at it very carefully. So anybody has a question, if Peter is here or anybody has a question on H1 and PERM salary being paid in percentages, please press *5. No new questions. Just follow up on percentage arrangement. *5 if you have a question. I see a lot of people just logged in. I want to remind people I had tweeted about this. I had put it on Google Plus. I have also put it on our Facebook page. I will not be able to take new questions today. We have a lot of questions to cover. So if unless your question is posted already, I will not be able to take it, folks. Sorry about that. Okay, not this time, but in 2 weeks we'll be able to get together again. The best way to get your questions answered is just post them. That way I always get to them. Let me go to the next frequently asked question, and then I'll start the regular questions. There's a question about naturalization after lengthy stay abroad. How do I get my citizenship? The rules are actually not that complicated. The rule in green card maintenance as well as naturalization is if you are outside USA for a year or more, you will lose your green card unless you have some protections in place. If you are counting that period for citizenship, normally you would lose the entire 5 years you have amassed. So if you got your green card in 2005 and in 2008 you left USA after 3 years and you want to count after 1 year, you'll have to start the 5 years of green card approval countdown again. So what does it require? 5 years from the green card approval. If you are married to a US citizen, that's 3 years. Half of that period for normal as well as spouse of US citizen, half of that period, 2.5 years, which is about 30 months for normal, and 1.5 years, 15 months for spouses of US citizen. Did I say 15 months? Is that 1.5 year? But whatever the 1.5 year is, whatever the 3 years is actual, 2.5 years, 2.5 years of actual presence. What am I saying? 2.5 years of actual presence. So half the period, 2.5 and 1.5. So once again, your green card must have been approved 5 years ago. If you were out for 1 year or more, you've got to reset that 5 year again, unless you had a re-entry permit. In that case, it's 4 years and 1 day, just to keep things interesting. But out of that, 2.5 years or 1.5 years, depending upon which category of naturalization you're applying through, would have to be physically present in the United States. Rule of absence less than 1 year, more than 6 months is you will probably have to explain why you were gone that long in any 12-month period. And if you were gone less than 6 months in any 12-month period, government doesn't usually bother you about it. Okay, so that's the general rule. Now, in your case, what happened was you received your green card in 2009. You had a serious issue with parents' health. 2010, you left, visited USA for 20 days. Next year, then finally you moved back to USA on October 17th, 2012. So it looks like you were never gone for over a year. And you already have 2.5 years of physical presence. So can you apply for naturalization? I think you can. I'm concerned about the muck they could dig up because you were gone so long. Sometimes it has happened with many people. You go for naturalization and you end up losing your green card. Okay, it has happened with many people. My advice would be think about applying in 2017. If you are a risk taker, you want to go for it, I would want you to take a second opinion so that somebody can go over your documents, go over your reasons, calculate the times, see what kind of documentation you can bring to the table if you're asked to justify your absences. Um, Only then you should file now. Otherwise, you should probably wait till 2017 because they normally just look at the 5 years immediately preceding the application. If you are on the phone, MSC guy, press *5 if you have a follow-up question. Anybody has a follow-up question on naturalization, press *5. No new questions, please. Okay. Let's go on to the next question. Once again, I repeat, folks, I won't have time for any new questions. I'm just doing the posted questions. Manglesh wants to know, once my H1 6 years are expiring, what are my options? Can I go to F1 status instead of going to India? Yes, you can. If you genuinely want to go to school, some people actually even get CPT. So definitely you have that option. If you go to my blogs on immigration.com, in the last three entries, one of the entries is CPT OPT issues. Read up on that. It tells you what kind of issues come up if you take CPT. As far as going to F1, plain vanilla F1, that's definitely an option. Can I come back to H1 after 2 months and 15 days, which is 365 days of green card pending? Yes, you can. And you are not subject to the quota. I don't see any reason for you to go to India. The only thing I would advise Mangleshji is that um, you should have a genuine intention of finishing the degree. I don't want you to go to school just to, just to pass time. You could probably do that by applying tourist visa as well. Um, all things considered, all of what you're thinking is possible. Whether it is advisable or not, that your unique circumstances will tell. If you are on the phone and have a follow-up question, press *5, please. *5. Okay, no questions. Let's go to the next frequently asked question. Once again, I'm doing the frequently asked questions first, and then we'll deal with the other questions. So here is another frequently asked question from Daya H1B. Daya says, I had the visa stamped, I got the H1, but I never worked for that employer. Can some company transfer this H1B? See, you got your visa approved since 2014, so it's within the last 6 years. Your petition approved. Then you got the visa stamped. As far as USCIS is concerned, you should be okay as long as, just remember this, as long as your old employer did not revoke your H1B before October 1st of 2014. I guess they did not. You got selected in 2013 lottery, you got the visa. So as long as whichever year you got selected, I guess 2013 October. If your visa stamping was after that, obviously that case was not withdrawn. So in my view, you should not be subject to the quota. You should be able to get your H1 transferred. Even though you currently are an L1, you can get an H1 through any company. Keep in mind, time you have spent in USA on L1 will be deducted from your H1 total period. If you're on the call, Dayaji, and you have a question for me, press *5. Anybody has a follow-up question on this, press *5. Okay, let's go on to the next question. Again, the next frequently asked question. Can I apply for H4 visa if H1 is rejected? The answer is yes, you can. Can I convert from H4 to H1? And yes, the answer is you can. So Ravi's question was, I'm an H1B, I-140 approved, wife is also an H1B. If I go for H1 visa stamping, get rejected in Hyderabad, can I go for H4? And the answer is yes. So can I convert back to H1B once I come on H4? The answer is again yes. But do discuss it with your lawyers. Make sure that everything else is okay with your case. But at least in principle, there is no problem with this approach. Anybody has a follow-up question? Or Ravi, if you are here, Raviji, *5, press *5. Okay. Two questions. Okay, 2 people. All right, let's start in the order. 3 people. Let's start in the order you folks logged in. I remind you, no new questions, just follow-ups on this issue. No new questions, please. New Jersey, go ahead, please. New Jersey. New Jersey, I can hear you. Go ahead. Newark, New Jersey, go ahead. Okay. Let's go to California. California, go ahead.
Sir, actually, I wanted to know. So for you said like we can get change from H4 to H1.
Right.
So basically, if there is the change of status, does it have to do again amendment also? Amendment and change of status, are they both together? Or?
No. I think what you're talking about is if I enter USA on H4, is it going to be again a two-step process or just one-step process to convert to H1? It will be a one-step process.
But if it is a new employer, so
still,
do we have to do amendment?
No, still a one-step process. Don't get confused about all this names. New employer,
Okay.
extension, amendment. Here is how it would work. You are not subject to the cap. You have the I-140 approved. You are entitled to 3 years of H1. You come back on H4. A new employer can apply for you, get you the H1, and convert you from H4 to H1 all in one step.
Okay.
Okay.
So will that cause any issues when we go back to India for stamping, because we will not get any new I-94, right?
You will get a new I-94 for the H1, but the I-94 is not the issue. Getting stamped in India or in any country for H1 has its own problems. They want to look at, if you have an in-house job with an established company, usually it's less of a problem. But if you are working in a consulting situation, you can be detained, delayed for a long time, many months sometimes. So, but that has nothing to do with the fact that you have or have not received an I-94, because the way I'm suggesting H4 to H1, you will get an I-94.
So when we change, you are saying we will get an I-94?
Yes, sir.
After change of status?
Yes, sir, you will.
Okay.
All right?
Okay.
Good luck.
Okay. Thank you.
You're welcome.
Hi, Rajesh.
1 second, ma'am. Yeah, go ahead, please. I can hear you. New Jersey, go ahead.
I have actually I exactly followed the same situation. I'm back to had my H1 rejected, so left to India and came back on H4.
Mm-hmm.
So my new employer was filing H1B for me right now. So I spoke to you before also. So you mentioned me that there won't be any wait time. So my just question was, can we work on the receipt number when we are doing the change of status? No, right?
Well, there's one issue that's obvious and there's one issue that's hidden. The obvious issue is that, of course, you cannot work on the receipt because the H1 portability is reserved for people who are already on H1. You are not on H1, you are on H4. So you can't work on the receipt. But the hidden issue is this. When you filled the forms for a visa stamping, there was a question on the form, do you intend to work in USA?
No, strategy. Actually, what they mentioned is they looked at my husband's status and they said, are you going to work in US? I said, I can't work on H4.
I think
they themselves told me that why can't you change to EAD and why can't you work? So that's the point they gave me.
So, but then what did you say to that? Did you say you wanted to work in USA or no?
I said if possible, yes. Yeah.
Oh, good. As long as you told the truth, I think you are okay. But many people get tripped up on this issue. So yeah, you're fine, ma'am. Go ahead. All right? Good luck.
Thank you.
All right. One more raised hand. I guess this is a popular issue. Kansas, go ahead, please. Kansas.
Sir, this is Ravi Kumar. I was the one posted. So,
Yes.
So am I considered as cap exempt at that point? With my approved
yes, sir. Yes, sir. Yes, sir. You are cap exempt because your H1 was approved anytime within the last 6 years. So you've had an approval, therefore you are cap exempt.
Okay, makes sense. So the cap exempt is tied to the approval of I-140.
Actually, no. I-140 merely gives you a way of extending your H1, which is a separate issue. When I look at your case, first thing I want to know is, are you entitled to any more H1? And the answer is yes, because you have I-140 approved, you are entitled to 3 years. My next question is there a problem with the quota? And the answer is no, because you had an H-1 approval within the last 3 years, last 6 years.
So what if I have passed the 6-year period?
When did your last H-1 expire?
My last H-1 expired in 2013.
Yeah, you're good. No problem.
But for in some scenario, if I'm going to India next year, maybe in 2017, at that point I will be in the seventh year of H1.
Well, you know, here is the interesting issue. It isn't the way USCIS has told us the last time we discussed this issue with them. What they said was, let's say your H1 was approved in 2010, but valid till 2013. To calculate whether you are cap exempt or subject, we will go with the year 2013 when your H-1B approval expires.
Makes sense.
Okay?
Okay.
Good luck.
Thank you.
You're welcome. Okay, folks. Once again, I remind some of the new callers, we won't be doing any new questions today, folks. No time. Just to follow up on the existing questions that have been posted. Sorry about that. I did tweet and I did inform people I will not be able to do new questions. I think this is the last frequently asked question coming up. Then we'll get started. So this question gets asked quite a lot. Can I file multiple PERM or green card petitions? Okay. First of all, generically, the rule is you can apply for as many categories of green cards as you like. EB1, EB2, EB3, through family, through husband, whichever direction you want to go, you can file all of them simultaneously. The second issue, can you file multiple PERM applications? The answer is, in principle, you can file unlimited PERM applications, unlimited, as long as they are being filed from different employers. So you cannot file for the same employer for the same job. And even if you try different jobs with the same employer, it gets complicated. So as long as you have the good faith intention to join whichever gets you the green card or whichever one you choose later on, you're not doing it just for an improper or inappropriate purpose. There is no limit to how many PERM applications you can file. What are the pros and cons, Rakeshji? You asked, what are the pros and cons? You can't file it through the same employer. I think you'll have a lot of problems. Okay? As long as a PERM is pending. Pending means whether the PERM itself is pending, or an audit is pending, or an appeal is pending. All of these are considered to be pending. Unless you revoke or withdraw the application and refile, you will not be able to file. And trying to withdraw an application when it's under audit or under supervised recruitment is a very bad idea. It reflects very badly on the employer. Okay. Anybody has a follow-up questions? Rakeshji, you are here. Press *5. No new questions, just follow-ups on this. *5, please. Okay. All right. We are done with all the. Oh no, there's another one. Sorry. Okay, there's another one. One more frequently asked question. I had a lot of these from Sriram. Also a very interesting question. And actually, L-1A, EB1C are some of my favorite categories, because if you have any kind of active business anywhere in the world, it can potentially be L-1A, EB1C can be the best way to come into the US. There is no specific investment required, unlike EB5, where you have to invest $1 million or 500,000, depending upon where you are putting your money. There's no requirement for creation of jobs, unlike EB5, where you have to create 10 American jobs. There's no requirement of getting a conditional green card. You just get the real green card all in one time. So L-1A, EB1C are a great option. Let's look at Sriramji's question. He's got 2 graduate degrees, computer engineering masters, and an MBA. He's a CTO in a well-known sporting goods company. They also has a bunch of successful businesses and serves as a board member and CTO of these companies with a presence in the US and India. I want to apply for a green card. I have the option of returning to India for a year to serve as a CEO for one of the companies I co-founded, and then come back. Okay, here is the problem. It's a great way to go if it works. By the way, I see there's a hand up. I'll get to that in 1 minute. I caught that a little late. So let me finish this and then I'll go back to that hand. In principle, there's no problem with this approach. You can go outside USA. You can work an executive or managerial level employee for a company that has a branch, affiliate, or parent or daughter company in the United States. And you can be transferred back on EB1C green card, straightforward, or just L-1A and then EB1C green card. In principle, this is a great way to go, yes. But what I want you to do is, I want you to have at least an hour, 2-hour discussion where all your documents are reviewed to make sure that your chances of success on an EB1C L1 1 year down the line are pretty good. Okay, nobody can predict what the law is going to be 1 year down the line, but chances of immigration law changing drastically before 2018 are quite small. Okay, so get a detailed discussion going, review potential job descriptions, review the company structure, and I think it's definitely, if this is an option for you, go for it. Okay, if you are on the phone, Shriramji, press *5. If you have any questions, follow-up questions, press *5. Okay, let me go to the hand that was raised. My old friend here. How are you?
Hello, Rajeev sir. How are you?
I'm good, sir. How are you?
I'm good. I'm so sorry. I was a little busy, and I guess I missed the answer you told me for my question.
What was which?
My mom has a
H1.
She was born in India,
right?
In Goa, and she was born before 1961.
Right.
And she is eligible to apply for Portuguese passport. So do you think that can help us to change the country on the EB2 category?
No, the country of birth decides which country you get charged to. Okay, now since Goa was a part of Portugal at that time, I think you might have a shot at going through Portugal. See, I'll give you an example. I'll give you an example. We have done many cases where people who are, I'm trying to remember which way we went. Yeah, we had people who were born in what is now Pakistan. But at that time it was undivided India. We were actually able to charge them to Pakistan. I don't know if this would work for you because it actually goes against what I just said. That means even though when she was born it was Portugal, now it is India. And even though when they were born it was undivided India, now it is Pakistan, we were able to take advantage. It's worth looking into. I do not know how this would work out. So the country of birth definitely governs, okay? Not the passport.
Okay, thank you. And my last question is, my brother is also on a conference call right now.
Okay.
And he came on H4 3 years back, and since he's gonna go 21 and above, he's gonna lose his status from H4.
Right.
But and we are thinking about F1. But here is a suggestion that I wanted. Do you think if we send USCIS or the immigration people a very good letter stating that if he can get a EAD or a work permit, or he can apply for DACA, but he did not came in 2007.
Well,
so do you think they're gonna work out something?
I would have him talk with the lawyer, go over the pros and cons. F1 has its own advantages. By the way, I have to cut short this discussion. I was not doing any new questions today, but since you have been calling in for so many months, I didn't want to disappoint you. I thought you had a follow-up question, and I don't think you realized that no new questions today. Okay, sorry.
Okay.
I got it.
No problem.
All right, bye-bye. This gentleman has been a frequent caller, young man, so I made a small exception here. We've got two more hands up. Let's go to Florida. Florida, go ahead. Florida.
Hello, Mr. Raji. This is Sriram Sridhar, the person who posted the EB1C question.
Right.
I mean, there are like a couple of things I maybe omitted out of the question when I posted it, and my follow-up was related to that. I mean, both with respect to our U.S. company, which has been in business for more than 10 years, we have a revenue of more than $10 million, and also employ close to 25 people here. And the Indian side of the company, which technically is a subsidiary because majority shareholding is through the U.S. company, close to 65%. And even the Indian company has been in existence for close to 3 years now and employs close to 20 people. I mean, does this have a padding or
yes.
length of existence? Does this have a padding?
Yes, looking at just the general overview, it looks like this could make a case for EB1, L-1A both. Yes.
And I did hear you saying I should have an extended discussion with an attorney. Are there any specific areas we need to talk about with respect to the corporate structure?
I think you should talk about the job description proposed in India. You should talk about the job description 1 year down the line in USA. You should talk about what businesses the companies do. You should talk about the ownership structure. You should know what the limitations on changes are, how far you can change things. You should know what the limitations on travel are. There's a bunch of things you should discuss, because if you plan for it right, that increases your chances of getting successful L1, EB1 dramatically. So yes, do have that discussion, okay?
Yep.
Good luck, sir.
Thank you, Mr. Rajiv.
You're welcome. Okay, and there is one more question, also from Florida. Florida, go ahead, please.
Hey, how are you?
Good, sir.
I'm calling because you've been here since 1992.
One second. I'm very sorry. I said this several times today. I will not be able to do any new questions. Okay, sorry. I'm very pressed for time today. All I can say is in 2 weeks we'll be back again. Post your question online if you want a response guaranteed. Just post it online, okay? Sorry. Okay, getting back to our track. Let's go back to the questions in order. So from Parthasen Gupta, in USA on H-1B with approved PERM, 2015 date, H-1B 6 years will expire in April. Employer is filing I-140 premium. Okay. My daughter is currently in India with my wife. She's on my dependent H-4, which will also expire on April 2015. In April 2015. 2015? You mean 2016, I think. I'm assuming you mean 2016. Currently, she's working in India and has to move to USA immediately for a new project. Okay. Can my daughter travel on H-4, which is against my H-1B, along with my wife, who has her own H-1B? Yes, she can. Is there a concern when there's only 4 months of validity? No problem. Even if she enters 4 days before her H-4 visa is about to expire, I do not see it as a legal issue. Okay? So if you're on the phone, press *5. Mr. Gupta, if you're on the phone, press *5. Okay? Let's go on to the next question. Rajiv 3008, currently on L-1B visa. I-94 is good till September 30th, 2016 through employer A. My current employer, I guess, has initiated the green card processing in EB2. I-140 filed in November, awaiting decision. PERM was approved, but the attorney did not get letter, so filed I-140 premium, can it be changed to premium? No. I'm assuming that your PERM, certified PERM was lost. If it was lost, you cannot convert it to premium. If I change my employer after my I-140 is approved, can the new employer initiate green card and maintain my priority date? Well, that's a complicated question. There is a blog entry. I want you to read my blog entries on two things. One is the carry forward of priority date. Current thinking of the government is yes, you can carry the priority date forward even if the old employer revokes your I-140. The new regulations, which are being considered right now, would allow you to carry the priority date forward even if the old employer revokes the I-140. Okay. What are the requirements? I think if they revoke it before it was approved for 180 days, yes, this is what the new regulations are thinking. See, I didn't pay too much attention to them. After I analyzed them, I let them go. And I think I made one or two small errors when I saw my own write-up. But overall, this is a good write-up on the new regulations that are pending right now. What do the new regulations say? If these regulations go through, which I fully anticipate they would within the next few months, one, by regulation, once an I-140 is approved, the priority date is yours. It cannot be taken away unless government revokes the I-140 for error or fraud. So if the employer revokes it, no problem. Currently, that is what the government thinks also, but they are putting it down as regulation. Another thing they are saying is, if your I-140 was approved and was pending 180 days, not only do you carry your priority date, I'm sorry, not pending, was approved and was approved 180 days ago, not only do you carry your priority date, you can actually get H1 extensions beyond 6 years based upon that, even if the I-140 is revoked by the employer. That's a good provision. I like that. Because previously the problem was if you left the employer and the I-140 was revoked by the employer, you could not get extensions of H1 beyond what you already have because the I-140 is gone. Okay. If I change the employer, PERM approved I-149 not filed, can I maintain my priority date? No, sir. You cannot. Not under the old regs, not under the new regs. If I continue on L-1B till September 2015, return to India, currently continue working with the current employer, will my green card process continue? You can have your green card continue. When the EB2 date of filing is 2015, can the company file for EAD from India? No. To file EAD, you have to file 485. To file 485, you have to be in USA in legal status. Okay. Based upon I-140 approval, can I get extension beyond 5 years if I continue on L-1B? That's a very interesting question. So the question is, first of all, you can't get L-1B extensions, but can I get onto H-1B after 5 years because my I-140 was approved? And I think you might be able to, but you would first have to get an H-1, won't you? It's a very complicated situation. I don't believe there are clear answers. I think a call to USCIS would be a good idea to sort through all these issues. Because on the one hand, your 5 years are over. You have to be outside for 1 year before you can apply for any kind of visa again, L1, etc., L1, H1, etc. On the other hand, you got the I-140 approved. That should give you the right to 3 years of H1. But you will be subject to the quota, that's for sure, I think. Okay. So there's all these issues floating around, and I don't think I have clear-cut answers. I have to spend some time on this. I don't believe there are any answers out there. Yours is a very unique situation. So Rajiv, if you're on the phone and have follow-up questions, press star 5. Star 5. Any questions, follow-up questions on this issue? No, nothing new, please. I will not be able to do new questions today. Okay. Next, 3 frequently asked questions. We did these. Then we've got Marcus Alvey. Started working for employer A from August 2013. They started the green card in Feb 2014. Left the employer. PERM got approved in the meantime. So I-140 is also approved. Employer A submitted I-140. question is, will there be any future problems if I go back and join employer A and continue my green card process? I don't see any problem. My only concern, it's never been a major issue raised by the government, but there could definitely be a question that if you wanted to work with this employer on a permanent basis, why did you leave them? So if you have a good, truthful answer for that, go ahead. But really, other than that, I don't see any other complication. And they've not really raised that issue too many times. I've only seen it raised once, and I've seen the situation happen many, many times. But that question was raised only once, about 10 years ago, in a Chicago case that we were doing. Similar situation like yours developed. And we were able to, of course, take care of that problem. In case I don't join employer, can my employer be used the approved I-140 to carry forward my priority date? You can carry forward your priority date. As I discussed just a second ago, listen to that, the question I discussed before this. You can carry your priority date forward, no question about it. Can I apply for H-4EAD for my wife with approved I-140 from employer A? The answer is yes. You just need an approval of an I-140. Doesn't matter which employer it was through. Okay. With the new I-140 portability rule, can I port my employer approved I-140 to employer B? You can never port I-140s. Even after 180 days, you can only port the priority date and the right to get H-1 extensions. You still have to start your green card all over again under the new regulations also. The only difference here is this. Only time you can carry forward your green card is when your I-140 is approved and 485 was pending 180 days, you can take a same or similar job and not have to do the green card again. Okay. If you're on the phone, press *5. *5. Marcus. Okay. Next question. Oh, I'm sorry. This was Virani. I thought he had not posted the question, but he has. Are you still on the phone? For some reason, I skipped your question. I'm so sorry. I thought you had not posted. Okay, well, I know how to get hold of you. So we talked about the Portuguese passport. Let's go on to Sridhar Rao M. Got my H-1B petition approved from company A. After the approval, there's no H-1 requirement in company. So I transferred my petition to company B. It is approved now. Company A has onshore requirement and they are processing my petition for stamping. Is there any chance my company A knows that I transferred to company B? No, you don't. They cannot find out. Folks who are now logging in, I will not be doing any new questions today. Sorry. No new questions today. I just saw a couple of people who logged in now. So yeah, I don't see any problem with you because company A cannot find out about transfer of company B usually. If you want to work with company A, you should be able to. You know, another thing is, I just thought of something. When you apply for an extension of an H-1 in the future, I think you have to disclose there. Look at the form I-129. I think there's a question there about prior H-1 approvals. So that's the only way I can think of they would find out. Otherwise, there is no other way. Okay. *5, Sridhar, if you're on the phone, any questions? *5. No new questions. *5. Okay. Let's go on to the next question. I-140 approved with previous company, not revoked. Then you left after the I-140 approval. You are in 5th year of H-1B. Current employer is starting on PERM process. Can I use prior employer's I-140 approval to extend H-1B with this employer? Yes, you can. There is no requirement that only the employer who got the I-140 approved can get your H-1 extension. If your I-140 was approved through X and you want to do an extension of H-1 through Y, no problem. If I decide to go back to my previous employer, do I need to restart everything? No, you don't. No, you don't. And the new rulings don't really help you much from what I can see. But just listen to my discussion a couple of minutes ago about watching out for just one angle. Government could say, if you wanted to work with this previous employer permanently, why did you leave them? As long it may never come up. I think it's very unlikely they'll raise this issue because it's your right to have a green card through a future employer. There's no problem there. Okay, so I think you'll be okay. Nishbal, if you have a follow-up question, press *5. Follow-up question *5. I remind people once again, no new questions, guys. I will not be doing any new questions, just the posted questions. Then Sri-K007 moved to US December 2015 with family on H-1B from India. I have somehow skipped a bunch of questions when I was reading them, I think, because I don't remember reading this. Anyhow, doesn't matter. Moved to US in December 2015 with family on H-1B from India, got H-1B approved for only 1 year. Valid till September 2016. Completed 5 years on L-1B during previous stay. Interesting. This actually clarifies one thing, that after 5 years of L-1B, you are still entitled to your 1 year of H-1B. I thought you would, but this confirms it because Sri has done exactly this. So I have questions regarding my wife who's on H-4 status currently. She's got an H-1B approved petition during 2015. Apply change of, once she wants to start working, can she apply for change? What is the best way to go? Apply change of status? No. I think I talked with you. I think you were on the phone, and we discussed this issue. And I told you that this is a one-step process, and you can do it premium processing, no question about it. What would happen is, she's on H-4 right now. Tomorrow she finds a job. The employer will apply for her H-1 and change of status all in one case. Okay. Then the next, what will the approximate cost for the whole process to the company? Premium processing for change of status. Yeah, you can do premium processing. Cost, etc. you can figure out. Our fees are on our website. If you go to immigration.com, and on the very top panel, there is our fees. Click on that. That tells you our fees and the expenses involved. Different lawyers charge different amounts, but we also have a table about what the normal other expenses are, like the filing fees and the premium processing fees. So you can take a look at that. Your question is, if I get my green card initiated through different employer, get my I-140 approved before my visa expires in September 2016, and get extension, and later apply for H-4EAD, how feasible is this approach? Yeah, it is definitely feasible. Once your I-140 is approved, you are entitled to 3-year H-1 extension. Once your I-140 is approved, she's entitled to H-4EAD. What are the challenges? I can't talk about that. That's too many things that can go wrong. What would be her I-94 validity? Coextensive with yours. If you get 3 years, she gets 3 years. Okay. Challenges can be many. This is like asking a doctor, how many ways can a patient fall sick? I mean, there are books written on that issue. I can't help you there. Shrike007, if you're on the phone and have a question, press *5. *5 on your phone. Okay, good. Once again, I remind people, I will not be doing new questions. I just saw 2 more people log in. I will not be doing any new questions today. Okay, Mr. Bond, go ahead, please. 007?
Sir, actually.
Yeah.
Sir, actually, if so current employer is not able to find her a job, if we search for a job through a different employer, so do we have to again do H1 transfer and he can, apply for it? How is that possible?
It's interesting. Actually, I discussed this question just about half an hour ago with somebody else. I thought it was you, but no, it wasn't you. Let's go back to the basics. Currently, she is on H-4, right?
Yes, sir.
She has an earlier approved H-1 from 2015, right?
Correct.
That H-1 was never withdrawn, right?
Yes.
Here's how it will work. Let us say she finds a job tomorrow. The employer will start her H-1. It doesn't matter what they want to call it, amendment, extension. Forget about those things, transfer. Don't worry about all that. What will happen is, in one petition, they will include both H1 and change of status. So it's not two different cases, it's just one case. Okay? So don't worry about the details, but it's definitely doable. I don't see why not.
Okay, sir.
All right.
If the current employer on whom the H1 is approved is not able to find a job, can we search through a different consultancy who can get the job and transfer his H papers?
Immigration law has no problems with that. I hope you haven't signed any contracts with the old employer, but immigration law doesn't have any problem with that. I can only comment about immigration law.
Okay, sir.
All right.
Thank you.
Good luck.
Thank you.
You're welcome, sir. Okay. Mohan, 1983. I am in the last year of my H1B, 11 months pending for my I-94, planning to apply for green card, a future basis. Is it legal to change employer in the last moment? Of course. No problem. If my I-140 is approved, how many years of extension will I receive? 3 years. Will it require any H1B amendment as there will be a change in employer? You guys get all tied down with these amendment and transfers and extension issues. It's a one-step process. When should this process be initiated? As soon as your I-140 is approved. Before that, of course, you shouldn't. As my spouse is on H1B status with I-94 valid till 2018, if there's any delay in getting my I-140 approved, can I change to H4 status? Why do I feel that I just answer all these questions? Maybe I'm repeating questions. I do not know. But yes, you can convert to H4 and then convert back to H1, and you will not have any quota issues. How soon should you shift to H4 status? The law is your change of status to H4 application must be received by USCIS before your current status expires. Will my current employer come to know if I apply for GC through company B? The answer is I don't see how they would find out. Okay. Mohan, if you're on the phone, Mohanji, press *5 if you have a follow-up question. *5. Okay. Next is ADYAD. I'm not sure what that stands for. Adi, I guess. Currently on AD and AP since 2012. AOS is pending since 2007. 2012, my wife was also on AP, had to leave USA. So now there's a lapse of her AP and she can't come back. I have 2 kids who are US citizens. Okay. The only way she can come back is through consular processing after my green card. No, you could convert to H1 and she can come back on H4. Why not? Why not? There is no appeal against AP. You can't get your advance parole like that. So can she come on a visitor visa? She can try. It's up to the government to give it or not to give it. It's highly unlikely that they will give the tourist visa in these circumstances. But if some extraordinary circumstances are there and the tourist visa is denied, you could even try humanitarian parole. But I think your best bet, sir, is H1 and H4. I don't know why you're not thinking along those lines. That's the most obvious choice. Okay. Press *5 if you are on the phone. Eddie, if you are on the phone, press *5. Okay. Let's go on to the next one. This one is a little lengthy. I'll do the best I can. A little bit out of time here. Currently in the 7th year of H1B, EB2 petition I-140 approved, 2014 date, more than 180 days. Job title change. So project manager designation and corresponding career path. Okay, let me give you the bottom line. The most important thing in this is the job duties. If your job duties are substantially different, your green card cannot be processed unless you intend to return back to the old job. Okay. So you were an engineer to project manager. Does it require an H1B amendment? Then the test is substantial change. So you need to talk with your lawyers and get their opinion whether this is substantial change. It can also require a new PERM if there is substantial change and you do not intend to take the old job. So you got your perm through engineer title, you change to project manager. Unless you intend to go back to engineer when you get your green card, and the jobs are substantially different, this process will not work for you. There is really H-1B amendment. It's an eyeball test. I can't give you a mathematical formula which will tell you how you will determine whether the job is substantially different. It's a mixed question of law and fact. So really, only your lawyers can look at the case and then decide for you what, in their opinion, is the right course to follow. Promotions require that under PERM that the offered job must be more than 50% different. It's a very strange formula. I mean, how do you can't really distinguish jobs by percentages, but that's what the government wants to see. So there's a substantial more than 50% change. You can then use the experience gained with the same employer for your PERM position. And how about the proposed regulations? I have a blog entry on that. Please read them. There is no benefit for any internal promotions prior to I-14. You're right. If you get internal promotion, you could actually have trouble if you don't intend to go back. So if you're on the phone, press *5. I'll try to answer one or two top questions you have. *5. Really, you need to get together with your lawyers and make sure that there's nothing in this case that's going to come back and haunt us. There are no mathematical formulas I can apply. G-315a. So the question is, you've got an RFE that says submit a properly completed form G-325a with your original signatures. Should I send one completed form with original signature or also make 4 copies? You might as well make extra copies. When you have a question like this, it's always a good idea to call USCIS. Make a note of what they told you, make a note of the date and the time, and that should protect you. But in my view, why take a chance? You can sign everything and send it back in. Do more than one. It's not going to cost you any money. Neil says, he asked this question before. Any follow-ups? I'm sorry, I forgot to ask. RDRD, you're here, *5. Okay. There's a whole bunch of people, but not the people who posted the questions. Okay, Neil 108. I'm on second H-1B extension. After the first one was approved for 2 years. I've started my green card process. I have filed the PERM. Once PERM is approved, can I file I-140 and 45 concurrently? Can I use my wife's country of birth, Panama? Who is under DACA status right now? Oh, see, I don't know any reason why the law requires her to be in status. I see somebody's hand is up. I'll be right with you. So I'm sorry, I do not know of any source of information other than contacting USCIS, see what they say. I do not believe that if your wife has a 10-year bar, that should stop you from cross-chargeability. But I did look into this. I did not get an answer from any source. But I think you're going to have to spend some time. Excuse me for 1 second. So you have to basically contact USCIS, and if you are hesitant about doing that, contact your congressman's office. Ask them to follow up on this question. I think cross-chargeability should be possible. Okay, let me go back to California. California, go ahead, please. I can hear you.
So my question was like, do I have to talk to USCIS for this?
Are you talking about, which question are you referring to, sir?
The same one, cross-chargeability.
Oh, cross-charge. Yeah, I think the best thing you can do is contact your congressman's office. Okay, and explain to them the issue. Tell them to find out from USCIS. They'll be only too happy to help.
Okay.
Okay.
And I know probably you haven't come anything like this kind, like.
No, I haven't actually looked. I looked. There was no clear answer that I could find. I think it should be possible because, see, I'll give you an example. You may want to put your phone on mute. There's too much noise from your side.
Yeah, sure. Go ahead. Sorry.
Okay. So, for example, let's say you are here in USA, and your wife is in Bangladesh, and she's Bangladesh born. I don't see any reason why you can't use cross-chargeability. We use it all the time. So what is the difference between that case and the 10-year bar? My guess is that at least common sense says it should be possible, but I have no legal precedent for it. Okay?
Okay.
Good luck, sir.
And the worst scenario is if we try, what would be the worst scenario? Just a denial, right, sir?
Yeah, the maximum is denial. They can't have a shot. All they can say is, no, we're not going to give it to you. Wait for your turn.
Okay.
All right. Good luck.
Okay.
You're welcome.
Thank you.
You're welcome, sir. Bye-bye. I preempted that. Okay, next question. Okay, we did this one. Question is, for a birth affidavit, can it be signed in a language other than English, even if the content is in English? As far as I know, yes. Because even if you look at the USCIS forms, they let you use the vernacular language for signatures. Look at the USCIS forms. They let you use any language. So my guess is yes. Can it be signed by an older sibling who's only 4 years older? Yes. Because the law is the person who's signing the form must be alive when you're born. They don't have to be adult when you were born. *5 if you have a question. PERM audit. *5 if you have a question. You don't. Okay. So let's go to Janus 99. My I-140 was approved in 2013. Planning to join new employer. Can they do I-140 porting? We've discussed this issue in great detail. But you will have to start your PERM and I-140 again. No question about that. If you can wait a few months until the new regulations are put in place, that would make you quite safe. Because right now there's been so much flip-flop from the government. Listen to the rest of the conversations I've had on this issue today about the priority date. I would rather wait and get the new regulations implemented than change. Okay, because that way you know you are secure and your I-140 is secure, and even your right to further H1 extensions is secure. Okay, *5 if you're on the phone and have a follow-up question. *5 Janice, press *5. Okay. Aparna says, I'm currently employed in F1 OPT expiring in 19th May. Employer is applying for my H1. Spouse is on H1, has I-140. If my H1 doesn't come through, can I apply for change of status to H4 EAD concurrently? Yes, you can. Many people do that. Will I receive both the approvals at the same time? Probably not. It takes many months. Many months. Best course of action, you can try this approach. You can go get H4 visa stamp and come back, then apply for EAD. Might be shorter, but I have no evidence or guarantee that it will be. Okay. Aparna, if you're on the phone, Aparna ji, press *5 if you have a question. *5. Okay. Good. Sharanjeet has a question. I have an old PERM. I got approval in 2010. I-140 also got approved in 2010. So I guess the current employer filed in PERM 2011. That's what you're saying, another employer. But that was denied. They filed MTR, etc., etc. You moved to Canada. Can I use my priority date for old priority date for the new green card filing? And the answer is yes. Definitely, if the old employer did not revoke the 2010 PERM, you are entitled to that priority date. There's no limit on that. If it has been revoked, government says you can still use it. I have my doubts about that, but there's definitely a possibility, good Sharanjit, that you're going to be able to use your priority date. Okay, you have to start green card all over again, but you should be able to use your priority date. Okay. Guri, if you are here, *5. If you have a question, press *5. Okay. Let's go on to Nishbal. If I'm on H-1B, I-140 is approved. If I decide to quit and go on H-4, is there an impact on my green card process? H-4 EAD, see, green card does not require that you must be on H-1. You could be on H-4, you could be outside USA. So I don't see any problem with that. If there are other aspects to your issue, I don't know. But the fact that you're on H-4 EAD by itself has no negative effect on your green card. If you're on the phone, Nishpal, follow-up questions, press *5. Okay, I don't see any. All right, last question for the day, guys. After that, we will finish. NK Gokula says, I got my H-1B extension denied in September and returned to India. Got my H-4 stamped, came back. New employer filed H-1 under regular processing. Can I work on receipt? No. You can only work on receipt if you are currently on H-1, and you are not. You are on H-4. Okay. All right, folks. By the way, Mr. Gokna, if you are here and you have a follow-up question, press *5. You are not here. Okay, very good. Folks, thank you for being here. As always, I appreciate this opportunity to talk with you. There's somebody who's here. Oh, I guess you are here, Mr. Gokna. Okay. But I'll talk with you again in a couple of weeks for the next conference call. We are back to our normal routine. Let me go and answer Mr. Gokna's question. Sir, go ahead. I can hear you. Newark, New Jersey, go ahead.
Yeah. Hi. Hello, Rajesh. I'm NK Gokna.
Ms. Gokna. Okay. My apologies, ma'am. I thought you were Mr. Gokna.
Actually, I just spoke to you. So you were asking me about the questions you asked. They asked me while the H2 stamping, right?
Right. Why am I doing it twice? So, I don't know what happened here. Okay, no problem. So yeah. So and you answered them. You said that I am going to go work, but I will not work on H4.
Yeah, I said I won't work on H4, but they mentioned me that why can't you work, because you can go and read the rules. That's what they said to me. So I just said that, yeah, good to know. So
no, I think you're okay, because you did not try to hide the fact that you would you had no intention of working on H4, but you're not committing beyond that. I think that's a good way to go. Okay.
Thank you. Thank you. And also one quick question that okay, I can catch up you on next call.
Listen, you are here. You waited so long. Why don't you go ahead?
Okay, thank you. So I have my I-140 approved with my previous employer, but it is not revoked. So with the present next time new employer which I'm going with, I'm going to change designation. So do I have to come back from the starting process for the green card?
Yes, you have to start the green card all over again, but you will carry your priority date no matter what your job is. You could go from being an engineer to a CTO or even the CEO. You will still carry the same priority date.
All right, thank you.
All right, good luck, ma'am. All right, folks, I'll see you in 2 weeks. Thank you all for being here. Bye-bye.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.